Hey folks, welcome back to the channel. Today we have a double feature in toxic relationships. First up, we've got a defendant who allegedly threatened to burn down his ex's home if she didn't kiss and forgive him. Gross. And then we have the defense attorney and prosecutor trading jabs like a couple in their own dramatic breakup. Let's watch as the judge tries to deal with both the defendant's meltdown and the bickering lawyers.
Mr. Moore, this magistrate is up there here on a criminal matter. Case number is 240-5985201, sir. You have an attorney. Go ahead, counsel.
Sandra Roberts, appearing on behalf of Mr. Moore, has been advised of his rights. Will stand mute. We ask the court to enter a plea of not guilty on his behalf.
Thank you. I'm going to enter plea of not guilty. Court dates are October 16, 2024, probable cause conference, followed by preliminary examination, October 28, 2024. Both matters are in front of Judge Giles. Okay, Mr. Moore, you have some bond conditions. One is you're not to have contact with Tiara Cogman. That means no person-to-person contacts her, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons. You are not to go to Ms. Cogman's residence on Outer Drive. Do you understand those bond conditions, sir?
Yes.
Okay. All right, Counsel Vincent, go ahead, Esteban, please.
Magistrate, good morning. Steve Vincent, P71917. I hope Your Honor can appreciate this. We're going to be asking for a $20,000 cash or surety. We're also going to be asking for a tether as well as a curfew. I know it's being charged as an MDOP. I know it's $1,000 to $20,000. But if we look deeper into this case, apparently this is an individual who isn't taking the breakup of him and his prior partner very well. We have this individual who allegedly is at the house destructing everything in this gal's house. But the most concerning part, though, is the allegations that this defendant, after what was said and done in this incident, asks that complainant to kiss him to make up, and that if she didn't, that he would do more destruction as well as setting the house on fire. That's quite concerning to the people, Judge. In addition to this, I have an incident date of September 23rd of 24. On September 30th of 24, because this complainant is in so much fear, a PPO was issued by the Third Circuit against this defendant as a direct result of the actions that allegedly he's been causing to this complainant. So we find him to be a danger specifically to this complainant, and respectfully, we're asking for the cash with monitorization.
Thank you. Counsel Roberts, go ahead, please.
Your Honor, can we just first hear from Attorney Vincent as to where he got the information of the personal protection order?
Yeah, sure. It was the CCH.
So that's information that hadn't been provided to defense counsel prior to the hearing that was being referenced during the hearing, Your Honor.
I can't. A CCH can't be forwarded.
You could at least give us the information that you're going to be acknowledging something that hasn't been provided to defense. And I would encourage the court to instruct Attorney Vincent to do so, Your Honor, because we're relying on his representation.
May I?
Okay.
If you, I'm just one thing. If you're interviewing the defendant, he should be telling you about this.
I'm asking you, Attorney Vincent, you're the one who stated something on the record. I'm asking you, where did you get that information from?
We're not going to go down that road. We're not going down that road. Okay. Was Counsel Vincent, what I want to know is this personal protection order, was it served on the defendant?
It's my understanding.
Does it say in the CCH that it was served?
I believe so, Judge. I can refer back to it, but
while you're looking at that, Counsel Roberts, please go to your argument.
Thank you, Your Honor. Your Honor, we will be respectfully asking for a personal bond. Mr. Moore indicates that he's 37 years old. Your Honor, at this time, he has no issue with not having any contact with the complaining witness. He indicates he has not spoken to her in almost 3 weeks, so I don't anticipate that to be any issue moving forward. Your Honor, he indicates he's a lifetime resident of the state of Michigan. He is a father of 2. He's currently staying with his mother. He is currently working. He works Monday through Friday, 7:30 a.m. to, I believe, 4 or 4:30 p.m. and is a college graduate, has a bachelor's degree. We're just respectfully asking that you consider personal bond for Mr. Moore with a no contact provision.
Counsel Vincent? Have you looked at the CCH?
I'm going through it right now, Magistrate.
Thank you. Well, let's start off with that court heard the representations. Court starts off with a personal bond basis. If it entertains monetary bond, uses clear and convincing evidence standard. Court reviewed the investigator's report, the allegations. Some other bond conditions are, there's no flammable liquids, okay, while this case is pending. Do you understand that, Mr. Moore?
Yes.
And what the court read and the allegation is that supposedly Mr. Moore made threats to the complainant that if she did not give him a kiss and forgive him, he would continue to do further damage and he would set her home on fire. And not only that, allege also is, while the allegation is when he was doing damage to the personal property of the complainant, is that it was done in the presence of their child, their minor child. Let me see. So, Counsel Vincent.
Yeah, Magistrate, I have, what I can tell you is I have the injunctive order, the domestic personal protection order that was issued 9/30 of 24. And I have a court docket number as well as what looks like a court number. It doesn't speak to whether or not it was served, because I have under the next paragraph remarks, and then I have conditions. Then following that, with a substantial amount of conditions, I have a notation that it was entered and forwarded, but I don't have anything, and I just want to be sure about this.
Yeah.
I don't have anything one way or another that speaks to that. I have it coming from the Third Circuit Family Division with all of those other particulars that I just gave.
All right, so, but there's nothing specific to say that he was served with the personal protection order. Is that correct?
No, I don't have one way or another. I don't have
Okay.
that.
All right, that's fine. Okay. All right. So it's possible that the defendant might not have known. You don't know. And even if he did know, he may or may not inform his attorney. But aside from that, what I do have, just going on the representations outside of the personal protection order, but the allegations in the investigator's report is that the court does find that Mr. Moore, he is a danger. Okay. Even though he's not charged with any type of assaultive behavior or assaultive charges, here it is that he destroyed, allegation is that he destroyed property belonging to the mother of his child, the complainant. What we're going to do is that court takes very seriously threats, potential alleged threats in this particular matter. And so what was the recommendation?
The people requested 20,000 cash or surety with some type of monitorization.
Well, he's going to get a GPS tether, work only. He's going to get a cash surety of $20,000. And Counsel Roberts, is this unaffordable or affordable?
Unaffordable, Your Honor.
Okay, so that means Mr. Moore, you're going to get another court date. Another court date that will be this Friday, October 11, 2024. 36th District Court. It's going to be in front of Judge McConnell or Judge Williams, who's going to look at the bond amount and bond conditions. Do you understand that, sir? Mr. Moore, do you understand the next court date?
Yes.
Okay, Mr. Moore, just let me say this, sir, so that if bond is made, okay, then you do not have to show up for the Friday court date. But if it is not made, you'll get another opportunity. You'll have an attorney that will represent you, okay, which can be the same argument, additional argument, new information can be provided to the court. And the court, like I said, will make, Judge either Williams or Judge McConaughey will look at the bond amount and bond conditions. Do you understand that, sir?
Yes.
Thank you, sir. That concludes your arraignment.
Thank you.
Thank you, Your Honor.
Step aside, sir.
The defendant's attempt to reconcile by threatening to destroy his ex's home wasn't a winning strategy. But what stole the show? The defense attorney and prosecutor acting like they were in their own toxic relationship. Who knew the courtroom could be this much of a soap opera? What do you think? Are these legal professionals just passionate, or did they take the drama too far? Let me know your thoughts in the comments, and don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. Thank you for watching. See you in the next one.